Hi, I'm John Cohen, partner at nextlaw.ca. We're Ontario's dedicated stunt driving law firm. So when you were charged with stunt driving or racing in Ontario, you received a summons to court, and at a later date, the officer will have to submit all of the details of the charge to the court in the form of what's called evidence or disclosure. Now, all of the steps of this process have to be followed according to the law, or there's a chance that your charges will get withdrawn or dropped. So let's investigate this. So getting charges dropped is not easy. Here's what's going to happen at court, at a court appearance for your stunt driving or racing charge. So there are limited ways in which a stunt driving charge can be dropped. So number one, there has to be a major flaw in the evidence or the disclosure. Two, something called an 11B charter argument that says the trial did not occur in a reasonable period of time. Or three, at the discretion of the prosecutor, that the charges are not, quote, in the interest of justice or in the public interest. Now, let's look at the major flaw in your evidence or the disclosure. There are many minor flaws or errors that can occur in your evidence, and these smaller errors can be corrected, and they usually don't constitute withdrawing the charges. They include such things as, the name of the person that's charged is spelled incorrectly, or the license number of the person charged is incorrect, or the license plate for the vehicle involved is wrong, the address where the offense allegedly occurred is incorrect, the date or the time that the offense allegedly occurred is wrong. For example, the officer might have forgot to sign the traffic ticket, the amount of the applicable fine is wrong, or finally, the offense charge is incorrectly shown. However, if there is a major error in your evidence, a seasoned law firm will find it, and it could mean the end of your charges. The reason I say seasoned law firm is because it takes a lot of experience to understand what constitutes a major error. If you try to find these errors yourself and you're not correct, you run the risk of going to trial and losing to the existing evidence. And if that's the case, then you would be convicted of the actual stunt driving charge and start at a minimum of the 1 year license suspension or $2,000 fine and much, much more. So the bottom line is, if you can get legal advice so you can make sure you handle your case properly, that would be ideal. Because remember, the prosecutor is the only person who can decide to proceed with the charges. Let's look at the 11B charter argument, trial in a reasonable period of time. This is not as simple as it sounds. The most important fact to keep in mind here is that the delay must be at the request of the province, not you. So to put simply, you can't keep going to court, delaying it, and then try to make a charter argument. It doesn't work that way. The delays based on your request do generally not count towards this reasonable time frame. Also, COVID has kind of frustrated this process. There were these series of Emergency Act measures during COVID that essentially froze time in the courts in Ontario. So that normal 18-month time delay frame, it stopped applying. And this continues to be a little bit unclear with these 11B arguments. Finally, this process for an 11B argument is timely and it's costly, and the court does not simply withdraw your charges based on this time period. You have to start what's called an 11B charter application and then present it in front of the courts, and it can get a bit tricky and it can get a bit legal. So you would need to complete you would need a complete history of your interaction with the courts, all sorts of other evidence, etc. And you may want legal help to move forward with any application like this. Finally, not in the interests of justice or in the public interest to get a charge withdrawn. Only the prosecutor can make this determination. Of course, having the right legal representative can influence this decision. This decision is generally not based on your circumstances or how you feel about the charge. Remember, the province simply needs to prove that the radar or laser device was correct. So you would have to have found a major error above or something else that is compelling enough to get the charges withdrawn. And again, it is always best to have a professional handle this, as their experience will give your case the best chances at finding this mistake that can convince the prosecutor to withdraw the charge.